Just waiting for Alexander Baranov from the legal aid offices. I'll maybe just wait just a couple more minutes. He texted me and said he'll be logging on shortly. Just waiting for him, and then we can start letting everyone in. Yeah, forgive me for the delay here. I'm just waiting for Alexander to join us. So it might just be a couple minutes late starting. Oh, добре. Добрий ранок. Олександр, пане Баранов, добре.
Доброго ранку.
Я сподіваюся, що все добре. Я читав на новині, вчора було багато повітряна тривога ще раз, але ми дуже раді, що ви тут сьогодні. І так, ми можемо, я думаю, скоро починати. Здається, що все наші спікери, професор Шабас is here, Gennady is here, you're here, and Irina from our Ukraine project is here too. So I think we can start if everyone's ready. Yeah.
Okay, so I cannot meet anyone.
Sure. Yeah. Добрий ранок всім. Дуже дякую сьогодні, що ви тут за наш webinar, our first webinar today. My name is Christopher Russell. Before we begin today, I wanted to provide just a few introductory remarks as moderator. The title of this webinar series, it's the first of three, is the application of international law and practices of defense counsel in domestic war crimes cases. The meeting is co-organized rather, by the OSCE Office for Democratic Institutions and Human Rights and the Coordination Center for Legal Aid Provision. My name is Christopher Russell, and I'm a rule of law officer at ODIHR. And before we begin today, I would just share a few technical announcements about the webinar today. Today's webinar is available in both English and Ukrainian language via live interpretation. You can access and change the interpretation language using the Zoom globe icon on the Zoom taskbar, or you can listen in the original audio, which is both Ukrainian or English. We do have an IT expert available with us today, so if you're experiencing any technical problems, feel free to write a question in the chat. I would be remiss to not thank our interpreters. Ms. Vinova and Ms. Igranova are with us today, interpreting simultaneously. So to facilitate good discussion, I would please ask, and I'll remind my own self of this, to speak slowly and clearly so that we have a good communication standard for us during the webinar today. All participants are welcome to ask questions or provide comments during the webinar and presentation. You can raise your hand during the session to ask a question, or if you prefer, you can also type your question in the comments bar. And I will remind everyone that today's webinar is by invitation only. It is private and it is recorded. In the case of an error rate alarm, please know that we first emphasize security, and we'd encourage everyone to find a safe place. And you can always listen later on to this recording after the error rate alarm is complete. Feel welcome to leave this webinar, and please place your own personal safety as a priority. I would be also remiss today to not remark on the tragedy that unfolded in Poltava yesterday. We're well aware of the very dangerous period right now throughout Ukraine and in all oblasts. So I want to make very clear that this webinar is recorded, and if there's a technical issue or you need to take shelter, please do so. With those announcements being made, I would like to introduce some of the speakers today who will provide some introductory remarks to the webinar. First, I would like to introduce the Chief of OSCE ODIHR's Rule of Law Unit. That's Mr. Gennady Barba. Gennady, the floor is yours.
Thank you, Christopher. Доброго ранку. Good morning. As Christopher said, we are part of OSCE. We are in the Office for Democratic Institutions and Human Rights, and as many of you know, we are based in Warsaw, in Poland. The mandate of our institution, of ODIHR, is to monitor elections and to support 57 states of OSCE in the field of democracy, rule of law, and human rights. But in Rule of Law Unit, we work very closely on what is called supporting and promoting independence of the judiciary and respect of the right to a fair trial. And as a central part in the right to a fair trial is, of course, the right to effective defense. Therefore, it's a pleasure for me to open this three-part webinar series today, hosted in cooperation between our institution, between ODIHR, and the Coordination Center for Legal Aid Provisions. I would like to welcome our esteemed group of participants and today's presenter. The webinar series is titled The Application of International Law and Practices of Defense Counsel in Domestic War Crimes Cases. And today's session is titled Select Topics in International Criminal Law, International Humanitarian Law, and International Human Rights Law. This event is the second we have hosted in partnership with the Coordination Center for Legal Aid Provision. We look forward to building our partnership in this type of events. I would like to send my greetings to the Center's Director, Mr. Alexander Baranov, and to the team of the 3 legal aid offices who worked to make this event happen. I would like also to thank our distinguished expert, Dr. Vільям Шабас, who is joining us today. And of course, I would like to thank and welcome the Ukrainian attorneys who are participating in this webinar, who represent various regions of Ukraine. This event is organized in the spirit of supporting your critical work as public defense attorneys, ensuring access to justice to indigent clients, while also safeguarding the right to a fair trial. As Christopher mentioned, yesterday we learned with sadness about the news of Russian attack in Poltava, where around 50 people died or were injured. And during these moments, as defense counsels, your work is inevitably subject to intense criticism from society, who demand accountability. However, as all parties in this webinar acknowledge, defending war crimes is a demanding and technical endeavor, even for most highly experienced legal professionals, and extremely important to be done. When it comes to OSCE commitments, ODIHR commends Ukraine's efforts to uphold its commitment as a participating state to the OSCE, which requires all parties to ensure the right to a fair trial, even during an emergency or time of war. I recall that all OSCE participating states have additionally committed to ensure respect in all circumstances for international humanitarian law. Participating states have furthermore committed to making all governments accountable to each other for their behaviors towards their citizens and towards neighboring states, and to holding individuals personally accountable for war crimes and acts in violation of international law. In the context of today's attacks on Ukraine, I'm reminded that the OSCE Action Plan for promoting gender equality calls for the support of national and international efforts to bring to justice those who have committed crimes against women under international criminal law. Today's webinar provides us with an opportunity to consider the topics of the core of these commitments in more depth and in a way which can support defense attorneys carrying out this vital work. With this, I again thank all the participants for attending, and I wish all of you a productive and engaging webinar. Thank you.
Thank you very much, Gennady. And next, it's a pleasure, дуже великий честь для мене, to introduce the director of the Coordination Center for Legal Aid Provision, Mr. Alexander Baranov. Alexander, please.
Дякую, Христофере. Дякую, Геннадію. В першу чергу хочу подякувати нашим партнерам, які сьогодні нам допомагають розвивати спроможність української адвокатури, здійснювати належний захист у справах щодо обвинувачення у скоєнні воєнних злочинів. Хоча з початку війни, мабуть, не було такої великої уваги до цього питання, і в першу чергу на той час підвищилася спроможність прокуратури, суддів здійснювати збір доказів. Для суддів також зараз продовжується підвищення їх спроможності, але дуже важливий елемент в системі правосуддя – це адвокатура. Завдяки нашим партнерам ми сьогодні продовжуємо і не зупиняємося, і це початок, як казав пан Христофер, але долучаються і багато інших партнерів, які теж допомагають підвищувати спроможність захисників, здійснювати належний захист. Це дуже важливо як для системи правосуддя, так і в цілому для країни, для іміджу країни на міжнародній арені. Доктор Шабас, мабуть, якщо дехто з вас дивився, якщо ні, у вас буде чудова можливість передивитися, ще в 2022 році за підтримки IBA, Міжнародної асоціації адвокатів, підготував невелику лекцію щодо міжнародних стандартів прав на справедливий судовий розгляд. То наша співпраця вже така багаторічна. І що найбільш важливо, що ми сподіваємося, що всі експерти, які сьогодні допомагають підвищувати спроможність, вони також на сьогодні ми маємо інформацію, що зголосилися підтримувати в подальшому, навіть в питаннях, якщо необхідно буде підтримувати в якості менторів українських адвокатів в справах щодо воєнних злочинів. Справ буде дуже багато. Ми сьогодні знаємо, що Офіс Генерального прокурора зареєстрував більше ніж 140 тисяч справ, кримінальних справ. Можливо, не всі з них дійдуть до суду, але все одно це виклик на роки. І ми теж всі бачимо, що відбувалося в інших країнах після конфлікту, і теж треба розуміти, що це наш спадок, це спадок на десятиріччя. 10-20, а в деяких країнах і через 30 років розглядаються справи щодо воєнних злочинів, які не мають строку давності. Також хотів би звернути, Олег, увагу, що нещодавно був ратифікований Римський статут, ну і відповідно знову-таки вже з'являються нові питання, чи будуть притягуватися, зокрема, українські військові до відповідальності у разі скоєння ними воєнних злочинів. І це теж питання іміджу країни на міжнародній арені, тому що справедливість, якщо ми говоримо про справедливість, не має бути тільки по відношенню до одних людей і, відповідно, не дивитися на інші ситуації. Наскільки я знаю, Офіс Генпрокурора вже відкривав декілька справ проти українських військовослужбовців щодо питань скоєння воєнних злочинів, на жаль. Ну, але знову-таки тут питання здійснення належного захисту і якісного захисту. Отже, бажаю всім гарного тренінгу, нових знань і, в першу чергу, використання цих знань в вашій практиці в подальшому. Дякую.
Thank you, Alexander, for your comments and your remarks and a good perspective into the importance of the work of all public defenders right now, the importance of defense. And if I'm not mistaken, I think Dr. Shabas will get into ratification issues as well. It's just a very timely moment to have this webinar with so many important issues going on. Дуже дякую ще раз. And lastly, I'd like to introduce Ms. Irina Sukina, the program manager of ODIHR's Ukraine project. Irina, please, the floor is yours.
Thank you, Christopher. Доброго ранку, шановні учасники і учасниці. Мене звуть Ірина Сухініна, я координую проєкт ОБСЄ БДІПЛ, який має назву «Просування людського виміру безпеки». Виступатиму українською, тому що я сама з України, і хочу перш за все подякувати моїм колегам за таку можливість представити наш проєкт, який працює не лише в галузі верховенства права, але й в інших галузях людського виміру безпеки. Проєкт реалізується в Україні вже більше 9 років, і за ці роки було багато досягнуто в різних галузях людського виміру безпеки. Але у відповідь на ту ситуацію, яка склалась після повномасштабного нападу Російської Федерації на Україну, наша організація переглянула і змінила проєкт після консультацій з представниками України.
Безобразная конференция, кто-то
експертами.
выступает, звук вообще не идет.
Пробачте. Я продовжу. Зараз я хотіла б доповісти про ті результати, які були досягнуті за 2 минулі роки реалізації проєкту. Підтримка українських правозахисників і правозахисниць залишається одним з ключових пріоритетів проєкту. І в останні роки було запроваджено кілька онлайн-курсів для моніторів, зокрема навчальний курс щодо навичок і технік проведення інтерв'ю з людьми, які перенесли травму. Також для українських моніторів у сфері прав людини було підготовлено і запроваджено навчальний інструмент, який має назву Starlight Stadium, і це онлайн-гра для українських моніторів. І на обидва онлайн-ресурси ми вже отримали чимало позитивних відгуків від українських правозахисників і правозахисниць. Крім того, впродовж останніх 2 років БДІПЛ активно працює у сфері протидії торгівлі людьми, зокрема над покращенням виявлення та ідентифікації дорослих і дітей, які стали жертвами торгівлі людьми. І в рамках проєкту була організована оцінка національних механізмів перенаправлення у 5 державах-учасницях ОБСЄ, які прийняли великі потоки біженців з України. Ми також провели навчання для представників громадянського суспільства та служб реагування щодо виявлення та підтримки жертв торгівлі людьми, і загалом було натреновано 275 людей з 42 країн ОБСЄ, які безпосередньо працюють з українськими біженцями. У партнерстві з урядовою уповноваженою з питань гендерної політики БДІПЛ організували кілька тренінгових програм та підготували посібник для мережі гендерних радників і радниць в Україні. І в наступному році ми плануємо продовжувати цю роботу і організувати академію мейнстрімінгу, щоб надати гендерним радникам і радницям подальші інструменти для сприяння гендерної рівності в Україні. Крім того, у відповідь на великий потік українських біженців до Польщі наш проєкт організував серію семінарів, загалом 7 тренінгів для представників української та польської молоді, під час яких молоді люди пройшли навчання в сфері толерантності і недискримінації. І зараз вони реалізують власні ініціативи в своїх громадах, спрямовані на розбудову діалогу і взаєморозуміння між представниками різних національностей. І остання галузь, яку я хотіла б сьогодні згадати, це моніторинг ситуації з правами ромів в Україні та у сусідніх країнах, куди прибули великі потоки українських біженців. БДІПЛ продовжує підтримувати ромських і проромських активістів і активісток, організовуючи навчальні програми з безпеки та захисту, а також з адвокації, у відповідь на ті потреби, які були висловлені українськими представниками ромської спільноти. І наостанок я хотіла побажати вам успіхів у вашій роботі, і я сподіваюся, що цей вебінар буде корисним для вашої роботи. Дуже дякую вам.
Thank you, Irina. Thank you very much for your comments and for all the important work you do. With that said, I think we've heard from all of our introducers today, and it's a pleasure for me to now move on to introducing our presenter. We're very, very grateful for Dr. Wільям Шабас to join us once again, very gratefully sharing his time with us today. If you're not aware, Dr. Wільям Шабас is Professor of International Law at Middlesex University in London, Emeritus Professor at Leiden University and the University of Galway, and Distinguished Visiting Faculty at the Paris School of International Affairs Sciences, Po. He has published many books and articles on international criminal law, to say the least. His most recent books are The Customary International Law of Human Rights and the published version of the course he recently delivered at the Hague Academy of International Law, entitled Relationships Between International Criminal Law and Other Branches of Public International Law. Professor Shabas is an officer of the Order of Canada and a member of the Royal Irish Academy. Dr. Shabas, thank you so much. The floor is yours.
Well, good morning, and thank you very much for the very nice introduction. It's a pleasure to be with you again. I suppose at least a few of the people who are attending were at the previous sessions that I've delivered in Ukraine over the years since the Russian invasion. And there have been, of course, developments. I propose to talk to you about a range of issues. I was given a lot of freedom in how to organize this, and I propose then to, I have a list of issues that I've listed on the PowerPoint slides. You have them in English on the screen, but I understand that the Ukrainian translation is available to everyone. It will be, of course, easier for me to follow the English version on the screen. Please absolutely feel free to raise your hand or to ask a question. I'm prepared to take this in any direction that would be useful to you in terms of the job that you have to do as defense counsel, as public defenders. Just on a technical level, I propose to take a break before the first hour is concluded for a few minutes, and then a second break, because I think that in this Zoom environment, it's really difficult, and it's not very good pedagogy to lecture for 3 hours, although I'm certainly capable of doing it if I have to do it. The introduction describes some of the things I do. What it didn't mention are two things that I think are relevant and maybe of interest to you. The first is that I'm the grandson of immigrants to North America who came from very near Lviv. And so when I hear about things like, as I learned this morning, the attack on Lviv that took place, I guess, overnight, every time I hear that mentioned, I have a particular, I'm particularly upset learning about it. And I visited Lviv in the past, and I've lectured at the university there in the city. The other thing is that I originally come from Canada. I moved to Europe to take up an academic position now about 25 years ago. But before I came here, I practiced law in Canada. I was a member of the bar, the Law Society of the province of Quebec. And I did many, many cases as a legal aid criminal defense lawyer. So I have a certain amount of experience doing the same kind of work that you all do. Although I must say that in the quiet life in Montreal, Canada, we never had to get involved in defending war crimes cases. Since then, of course, I've become more of a scholar and an academic specialist about international criminal law, and that includes war crimes. And so we're essentially going to be talking about war crimes here today. It's been mentioned already, and I hope you won't be disappointed at this. I do intend to speak about some of the issues relating to the ratification of the Rome Statute, which was announced by your president in recent weeks. I can't remember the exact date, but the plan to ratify the Rome Statute, Ukraine will thereby become the 125th state party to the International Criminal Court, member of the International Criminal Court. And we should talk a little bit about some of the changes that will mean and how that may affect your work and your lives. One of the things that occurs to me that it should be of interest to you is the possibility of working at the International Criminal Court, because there is going to be a call for defense lawyers who are not only familiar with the factual environment in Ukraine, but of course have the linguistic skills as well. You should know that at the International Criminal Court, there are two working languages, English and French, and really, to be quite fair, English is an awful lot more important than French at the International Criminal Court, although the main cases that they've been dealing with in recent years come from French-speaking Africa, where the lawyers do need to be able to function in French because they have to speak to their clients. You don't need to wait for Ukraine to be a member of the International Criminal Court before applying to be on the list of counsel. And perhaps some of you have already done so and have taken that step. But the information about how to do this is available on the website of the court. I myself am listed on the list of counsel at the International Criminal Court. I was involved about 10 years ago in a case dealing with someone accused in Libya in North Africa. But the accused was in Libya and still is, and nothing ever emerged, so I never actually got directly involved in the case. But I follow the work of the defense counsel there, because as a member of the defense bar at the court, I get the emails and everything about their activities. Anyway, this is something for some of you to consider, that there will be a need for Ukrainian-speaking lawyers with experience in the Ukrainian justice system in The Hague at the International Criminal Court. Ukraine, of course, has been subject to the jurisdiction of the International Criminal Court now for about a decade. But by virtue of declarations that Ukraine made, this is a very exceptional feature of the Rome Statute, and it's really only been invoked in a few cases, that a state which is not a member of the court can still accept the jurisdiction of the court. And this is what Ukraine has done on 2 occasions now in the last decade, and that provides the legal basis for the the investigating activities of the International Criminal Court in Ukraine, and of course, the arrest warrants that have been issued now against Russian leaders by the prosecutor, by the judges of the International Criminal Court. What Ukraine needs to do now is simply deposit the instrument of ratification in New York at United Nations headquarters. Whether it needs to get legislation in force inside the country and to have that authorization is a matter of domestic law that I'm not really personally qualified to comment about. There obviously are some internal steps that have to be taken, but looking at it from the outside, all that is really necessary at this point is for the ambassador of Ukraine in New York City at UN headquarters to walk into the secretariat and hand over a letter saying, "We're in." And when that happens, according to the Rome Statute, you still have to wait a minimum of 2 months for the statute to enter into force. It won't change a great deal because of the fact that the declarations are already in force, with perhaps one issue which has attracted a lot of international attention, and I'm sure is a matter of discussion and debate inside Ukraine as well, is the idea that Ukraine could make a declaration under Article 124 of the Rome Statute, excluding the jurisdiction of the court over war crimes. So you probably know that the International Criminal Court has jurisdiction over 4 categories of crimes. Genocide, which is covered by Article 6, and which has a definition of the crime that's derived from the Genocide Convention of 1948. Crimes against humanity, which is Article 7, and we can think of crimes against humanity as being gross or systematic or serious violations of human rights that can be committed in peacetime as well as in wartime. And war crimes, which are covered by Article 8 of the Rome Statute, and this is our primary interest. And then finally, the crime of aggression, which is governed by Article 8 bis. The reason why it's Article 8 bis is that it was not in the original version of the Rome Statute. And when amendments were adopted to provide a definition of the crime of aggression, it was necessary to insert it in the section of the Rome Statute dealing with the definitions of crimes, rather than to list it after the final article in the Rome Statute, which was Article 128. So the definition of aggression is inserted in between Article 8 and Article 9, and it's given the number Article 8 bis. When the statute was adopted at the Rome Conference in 1998, and I should mention that I was a participant in the conference. I attended the debates in Rome over 5 weeks when the Rome Statute was adopted. There were a number of compromises that were made with a view to securing as unanimous as possible support for the package that was being adopted for what became the Rome Statute of the International Criminal Court. And one really very exceptional measure was taken, allegedly to satisfy the military in France, who were nervous about the war crimes provisions. The generals from France had raised questions about it, and so the compromise that was made was to provide for a very special article, Article 124, which enables a state, when it ratifies the Rome Statute, to make a declaration excluding jurisdiction over war crimes, so that a state that makes such a declaration recognizes the jurisdiction of the court for genocide and for crimes against humanity, but in a sense gets a holiday when it comes to war crimes for a 7-year period. This has only been invoked twice, once by France, of course, and then subsequently by Colombia in South America. The provision, Article 124, has a sunset clause, has a clause that brings it to an end after 7 years. And even before the 7 years had expired, France withdrew the declaration. Of course, there have been no prosecutions against France ever. It was never an issue, and there have been no prosecutions against Colombia either for anything. So this was really, there was a lot of noise about this issue, but finally it was quite insignificant. When the Rome Statute was reviewed at a conference in Uganda in 2010, there was general agreement that Article 124 should be removed. But this requires an amendment to the statute, and under the statute, the only way you can succeed with an amendment is to have 7/8 of the member states agree to the amendment. And so this amendment that was later finalized in, I think, about 2015 or 2016, has now been available for states to ratify, and very few of them have done so. I think perhaps 20 or 25. And so Article 124 remains in force and is likely to do so for perhaps another 40 or 50 years, unless states change their attitude and move quickly to remove it. Well, as you know, it's been suggested that Ukraine could invoke this, and it's been proposed, and this has generated a lot of debate. Let me tell you what my main concern is about Article 124. And that is that Article 124 says that the court shall not exercise jurisdiction over war crimes committed on the territory of Ukraine for 7 years following the ratification, to me, that could have the consequence of bringing an end to the prosecutions that are currently underway. In other words, it would be the end of the arrest warrant against Putin, Lvova Belova, and the military personnel who have been charged. I can't be absolutely confident that this is the impact, and other observers have taken a different view of this. But we don't really know the answer, and we won't know the impact of Article 124 until it's invoked. And then we will see if it has that consequence. The judges will decide. But you go to court every day, you know as well as I do that we never know what the judges are going to decide. We often have ideas about what they'll decide and what would be reasonable, but really it's difficult to predict what the judges will decide. And when it's difficult to predict what the judges will decide, and Ukraine has an option about whether or not to invoke Article 124, it seems to me it's very dangerous that this would happen because of the possible consequences for the ongoing prosecutions, which are based on provisions in the war crimes part of the Rome Statute. So I wanted to flag that issue. Again, it's not the people in this webinar who are going to be deciding whether or not Ukraine invokes Article 124 or not. But the consequence is, it seems to me, uncertain and dangerous for the current prosecutions. And for that reason, my own view is that it would be very unwise for Ukraine to adopt Article 124, to make the declaration under Article 124. Of course, it may be politically necessary in order to secure enough of the support that's needed within the government and within the military to do so. I'm not really in a position to venture an opinion about this. One of the consequences, of course, but this applies already because of the declarations that Ukraine has made recognizing the jurisdiction of the court, is this relationship between the domestic legal system and the prosecutions undertaken by the International Criminal Court. You probably already know the word complementarity. This is a term that's used in the law of the Rome Statute. I don't think that the word complementarity actually appears anywhere in the Rome Statute, but we do say that the Rome Statute is complementary to the national jurisdictions. And the idea here is that there is a preference, there's a presumption in favor of the domestic jurisdiction over the International Criminal Court. And this was also something that was a kind of compromise that was part of the negotiations of the Rome Statute. Some international criminal tribunals, certainly the existing models in 1998 when the Rome Statute was adopted, did not have this notion of complementarity. They had a system of what we called primacy. And what that meant was that if the International Court wanted to prosecute a case, the domestic jurisdiction had to stop. And that was the situation that prevailed with the International Criminal Tribunal for the former Yugoslavia, which came into operation in 1993, 1994. And then for the International Criminal Tribunal for Rwanda, which came into operation in 1994 and 1995. And the much earlier models, the one that's important for our purposes in Europe, which is the Nuremberg Tribunal. There was no question of prosecution at Nuremberg being stopped because German courts were prosecuting the case. So the Rome Statute adopts the opposite approach, and this is to enable states that join the court to resist the court getting involved in prosecuting cases where its system is active. And this will mean if there are concerns, for example, that Ukrainian soldiers could be prosecuted for war crimes, in principle, the simple solution to this is to have the Ukrainian justice system undertake the prosecutions. In principle, if there is an investigation or a prosecution involving Ukrainian soldiers, Ukraine can resist the International Criminal Court being involved in the case to the extent it can demonstrate that it is investigating and prosecuting the case. This is an area of law under the Rome Statute that is not entirely clear at the present time. I can give you the simple version, but it's important for me to tell you that this is, like many issues of law, not always as straightforward as it seems, because in some ways it hasn't, the whole system and the functioning of it has not been entirely tested properly. One of the reasons for this is that early in the history of the International Criminal Court, countries adopted an approach to this relationship between the domestic system and the International Criminal Court that was a cooperative relationship. It was like a division of labor. It was a friendly relationship where the country said, you deal with these cases and we'll deal with the others, knowing, of course, that the resources of the International Criminal Court are themselves limited. It's only done a very small number of trials since it started its operations more than 20 years ago. It's not thinkable that the International Criminal Court would either take on a number of cases from Ukraine. It already has the ones dealing with the Russians, but also that it would deal with most of the, what we might call the lower level offenders. It doesn't have the resources to do this. I don't think it's realistic to be concerned about this. It's really only a matter if senior officials within the Ukrainian military were being charged with war crimes or other crimes, genocide, crimes against humanity, that the issue would arise. And so I don't really think that this should be a great or a significant concern. But just to say that it's an area that's in flux. One of the messages one gets from reading the Rome Statute is that the court has to be able, if it wants to fight off a state that's resisting the involvement of the court, that the prosecutor has to be able to demonstrate some kind of lack of genuine attention to the prosecution of the case. In other words, it has to show an attitude of the government, of the state in question, that is resisting the prosecution and attempting to defend people from being properly prosecuted. And the court has not really applied that. And instead, it's adopted a notion that it calls mirroring, following a mirror. The investigation of the state has to mirror the investigation of the court. And only then can it fight off the court and resist the court. So it means in practice that if the court rather is investigating a Ukrainian military official, that the prosecutor in Ukraine would have to demonstrate that it actually is conducting a genuine investigation into that particular individual. I think that's the state of the law as it now exists. But again, I don't think that this is really a matter of great concern. So this is what's facing us, what's in on the agenda in terms of ratification of the Rome Statute. Just one final issue that's developed in the last day or two, which is the issue of the refusal of Mongolia to enforce the arrest warrant against Vladimir Putin. As you know, Putin went to Mongolia a couple of days ago. Mongolia is a member of the court. It's a state party. It even has a Mongolian judge who is one of the 18 judges of the court. To be elected a judge of the court, you have to be a national of a state that's joined the court, and perhaps in the next round of elections, we'll have a Ukrainian candidate to be a judge at the court. You can't do it right now, because until Ukraine is a member of the court, you cannot have a Ukrainian national as a judge of the court. But Mongolia now has really defied the demands of the prosecutor that it arrest President Putin. I was lecturing about this here in Paris yesterday, and one of my students asked the question saying, well, this shows how useless the court is and how ineffective it is. And my answer was that, well, you know, it was probably asking a lot of Mongolia, given its own vulnerability, to attempt to arrest the head of state of its powerful neighbor. That would be that would be a dramatic move for it to undertake. But the fact is, the proof of the effectiveness of the court is that Putin will never travel to Poland or to Germany or to France or to the United Kingdom or to Canada or to Italy and so on. So there are many, many states. I think Mongolia must be perhaps the only one, or one of very few states, that would be prepared not only to allow Putin to visit them, but that would refuse to arrest him. So to that extent, I think it's not right to say that the court is ineffective. So that's really what I have to say about the International Criminal Court. Let me move now, unless you have questions about the International Criminal Court, let me move to talking more about war crimes. Are there any particular questions about this?
Dr. Shabas, I think you addressed the question, but I did see one in the comments section from Nina Corbina, and her question was, well, first about America's refusal, perhaps a bit off topic, but if you're welcome to address it. And then the second question, the consequences of Ukraine's ratification for the Ukrainian military.
Okay, now I'm just trying to get to the chat because it's difficult when you're lecturing. Here it is. What is the reason for America's refusal to sign the Rome Statute? What are the consequences of Ukraine's ratification for the Ukrainian military? Well, the United States has given various reasons at different times about why it won't become a party to the International Criminal Court. It's not unusual. The United States has often done this with international mechanisms and institutions, that it's more than willing to encourage other states to do this, but not prepared to do it itself. That's as much as I can say. The United States has often expressed considerable enthusiasm for the court, as it's done with regard to the investigation by the court in Ukraine. And in fact, the International Criminal Court has brought in an American military prosecutor with great experience to direct the investigations in Ukraine. So the US is very favorable there, but it obviously takes the opposite view when it comes to the investigations into the leaders in Israel. As for the consequences of Ukraine's ratification for the Ukrainian military, as I said, I don't think that they are very significant. The Ukrainian military have to obey the laws and customs of war anyway, and they would be subject to disciplinary or criminal proceedings in Ukraine if they were to violate the laws and customs of war. I don't see why they should be concerned about ratification. But certainly, if Ukraine is to ratify the Rome Statute, it can expose them to prosecution, except that with Ukraine's declarations, they're already exposed to prosecutions. I don't think there's any change for them, really. I see that Jacob Bonavie has a question. You have the floor, Jacob.
Thank you, Mr. Shabas. I had just one question, and thank you for a very interesting overview of international criminal law and the court. And as you said, things are not always very clear in this, not straightforward, as things haven't been tested. But I had one long-standing rule is that the immunity of state leaders, and as you touched upon, Putin's visit to Mongolia, and I've seen a few articles on this in the last few days that I agree it would be a very bold move by Mongolia to, if they were to arrest Putin, which would then obviously cause grave reaction from Russia. But in terms of state immunity for state leaders who are also wanted for, or acting state leaders who are in position, like would Mongolia also then, there are two conflicting strong principles here. You are a wanted criminal, and you are also the president of a sovereign state. How do you see, I mean, I know there's no straightforward answer, but how do you see the relations between those principles?
Well, thank you for the question. I think it probably gets to the heart of the debate we would have with Mongolia if they were ever questioned about why they have taken this step. I don't know who's advising Mongolia, whether they are getting advice from international lawyers from outside Mongolia or not, or whether they've just figured out the issue themselves. But if I were acting as counsel to Mongolia, or if the president of Mongolia asked me, do we have a reasonable argument, it would go something like this, that the Rome Statute, Article 27 of the Rome Statute, declares that there's no immunity for us, for leaders of a state that before the court, but that Article 27 only applies to those states that have ratified the Rome Statute. So the argument would be that Ukraine, for example, can give the court jurisdiction over the head of state of another country, or it can give the court jurisdiction over war crimes committed on its territory, but it can't give the court jurisdiction over the head of state of another country because it can't exercise that jurisdiction itself. It has to respect the immunity of the head of state. I think that would be the beginning of the argument. But then the problem is that the appeals chamber of the International Criminal Court has already addressed this question. Several years ago, there was a whole series of cases involving the president of Sudan, al-Bashir. And al-Bashir traveled to more than 30 countries, including Russia, including China. I don't know if he ever went to Mongolia, but he traveled around and he went to several states that were members of the court, Jordan, South Africa, Chad, and they refused to arrest him. The court said, you have to arrest al-Bashir. There's an arrest warrant against him. And they refused to do it. And so finally, the case went to the court and went to the appeals chamber, and the appeals chamber, which is the higher chamber of the court, ruled that there was no immunity for President al-Bashir, that the Rome Statute didn't provide for immunity, and that therefore he should have been arrested by Jordan or South Africa or Chad. And so the answer to Mongolia, people will say it's been decided by the appeals chamber. Now, Mongolia's lawyers then would say, well, we don't agree with the appeals chamber, and we're bound by the Rome Statute, but it doesn't mean that we're bound by every decision that the appeals chamber makes, because we're a sovereign state and we're entitled to have our own interpretation of international law. And if you really want to know the answer, let's go to the International Court of Justice and get an answer from them on the question. And we don't have that. What we do is we have a judgment from the International Court of Justice that's now more than 20 years old, saying that there is, in fact, immunity for a head of state. And there's an incompatibility between the ruling of the appeals chamber of the International Criminal Court and the judgment of the International Court of Justice. I wouldn't be entirely confident that the judges of the International Court of Justice would uphold the position taken by the judges of the International Criminal Court. So I think that those would be the arguments that Mongolia would raise. I think that just at a practical level, you can just imagine if Mongolia were to arrest Putin, then Ukraine wouldn't be the only country probably to be invaded by the Russians. I mean, it's very hard to imagine that practically what would happen. Would World War III begin? I mean, this is something that's so unimaginable and so unthinkable. It doesn't seem, in some ways, in any way reasonable to expect that Mongolia would arrest President Putin. It might have been desirable for them to just tell him not to come, but perhaps for their own, where they sit in the world geographically, they may have felt they had no alternative but to greet him, even though it puts them in an uncomfortable position within the International Criminal Court. It's now 10 o'clock. It's the top of the hour wherever we are, and I think it's time to take a 10-minute break. So my clock says 9:57, which I think is 10:57 in Ukraine. And so let's take 10 minutes and resume at 11:07 your time. Take a break, please.
Started amendment to the Criminal Code of Ukraine, and it was, let's see, attorney, forgive me here. Yes, Attorney Mykola Pashkovsky had a question about essentially amendments to the Ukrainian Criminal Code that are implementing the ratification. And we discussed this a bit previously, but obviously some of that's still to be determined. It's a draft law. He was curious about the effect of the crimes against humanity being codified into the Ukrainian code.
Okay. Well, I think it's time for us to resume after the break. And so let me speak to these questions that you've just raised with me. I don't think anybody knows exactly what the legislation in Ukraine will look like. To some respects, Ukraine doesn't have to enact any legislation. There's no requirement in the Rome Statute that a state enact legislation in order to ratify the Rome Statute. There's a lot has been written about what it's desirable for states to do. So in order to address this issue of complementarity, a state needs to be in a position to say that its laws enable it to prosecute the same crimes as those that are punishable under the Rome Statute. If it can't do that, then it's left the door wide open to the court intervening, which may or may not happen. But not all states that have joined the Rome Statute have enacted such legislation. With regard to war crimes, I don't really think there's any serious difficulty with the current provisions of the Ukrainian legislation. It's Article 428 something.
438. Yeah.
438. That Article 438 of the Criminal Code is such a broad general provision that it covers what's in the Rome Statute. I've been told that one of the proposals was to change the name of the provision, which is currently violations of the laws and customs of war, which is an archaic formulation, and to replace it with war crimes, which is the provision that we use, which is the title we use in Article 8 of the Rome Statute. And I was concerned, but I think that my concern was misplaced, that the intention would be to replace Article 438 with a text that is in effect a mirror of Article 8 of the Rome Statute. And I think the problem with that, it's not a problem for the International Criminal Court, I should say. It has nothing to do with the International Criminal Court, but it would have the consequence of narrowing very considerably the effect and the reach of the Criminal Code of Ukraine, because the Rome Statute provision is not a broad provision. It's a list of codified war crimes, but there are war crimes that are not included in the Rome Statute, and they would be missed. So it wouldn't be wise at all for Ukraine to replace Article 438 with Article 8 of the Rome Statute, because this would actually have the effect of shrinking, of narrowing the scope of the ability to prosecute war crimes. So I think that was the first question. Remind me what the second issue was.
No, I think you more or less covered it. Yeah, thank you.
Okay. Well, this all, of course, brings us to the issue of the sources of international criminal law, which we can examine in a very broad way, and to some extent that's what I'm doing here on the slide, or we can examine how these sources impact upon the law in Ukraine. So the starting point when we're dealing with international criminal law is the Hague Conventions. Two of them were adopted more than 100 years ago, one in 1899 and the other in 1907. And they are entitled the Hague Conventions on the Laws and Customs of War. So this is where that phrase that's used in the Ukrainian legislation currently comes from, the Laws and Customs of War. And the title itself tells us that there are laws of war, which were then still in a very formative, very early stage of formulation, codification, but that there are also customs of war, that there are laws of war that there are rules applicable in armed conflict that are created by custom rather than by the text of a law. And we see that idea reflected much later in things like the Statute of the International Court of Justice, where we recognize that there are two main sources of international law in general. One is treaty law, laws, written down, codified laws, and the other is customary laws. Well, for our purposes, what's important about the two Hague Conventions is that they are the first attempt to codify what these laws and customs actually are. In some places, they use formulations that are clearly irrelevant, anachronistic. There's a provision in there about the protection of the person who goes to negotiate peace, who is supposed to wave a white flag and be accompanied by a drummer or a bugler. And we don't see that anymore. We haven't seen that for 100 years. So there are some parts of the Hague Conventions that are irrelevant today. The other thing that I think is important for our purposes is that they don't list any crimes. These are not, and the notion is not in the Hague Conventions that there are war crimes. So the Hague Conventions deal with violations of the laws and customs of war, but not necessarily war crimes. And the distinction here, of course, is that a state can be responsible for violating provisions of the Hague Conventions, but that doesn't mean that a war crime has been committed. Now, subsequently, when prosecutions for war crimes were developed initially at the end of the First World War in 1919, although very few of them took place then, but then at the end of the Second World War, when we had international prosecutions at the Nuremberg Tribunal, but we also had a huge number of national prosecutions for war crimes, judges and courts turned to the Hague Conventions with the idea that the Hague Conventions provided guidance as to what war crimes actually were. And I think today the proper view is that the Hague Conventions contain a list of serious violations of the laws and customs of war, and that where something is a serious violation of the laws and customs of war, then it's a war crime of an international character. But certainly there would be some violations of a more minor nature of the Hague Conventions that we would not consider to be war crimes, certainly not war crimes under international law. One final point about the Hague Conventions, that they, although they are archaic, that we still turn to them today. And to give you a very concrete recent example, about 7 weeks ago, the International Court of Justice, the World Court in The Hague, not the International Criminal Court, but the United Nations World Court, the International Court of Justice, you all know about it because of the Ukrainian cases there. The International Court of Justice relied upon the Hague Conventions when it issued an opinion about the occupation of the Palestinian territory. And we have a very detailed and interesting advisory opinion from the International Court of Justice. It was issued on 19th July of this year, where they address the law applicable in an occupied territory, therefore clearly of relevance to the Ukrainian territory that is occupied by Russia, and where they refer to the Hague Conventions as one of the sources of law. And so I have not given greater thought now to the relevance of the Hague Conventions to the discussions about the law applicable in occupied Ukraine, but certainly it's relevant. And anyone doing a thorough legal analysis of the applicable law in the occupied parts of Ukraine will need to refer to the Hague Conventions. I dare say that it also applies to that little bit of Russia that's now occupied by Ukraine, that the conventions would also be applicable. And the other point is that the Hague Conventions, even when they don't technically apply because of issues of ratification and so on, they have been very generally held to represent customary law that is enforceable, even in the absence of the technical application of the convention. The Geneva Conventions are, of course, the second major source of applicable rules of international criminal law. And unlike the Hague Conventions, they make provision for war crimes. They don't call them war crimes in the Geneva Conventions. They call them grave breaches of the Geneva Conventions. But the principle is the same. These are crimes that are punishable internationally, and that states have obligations to prosecute. And the Geneva Conventions are, of course, universally ratified, and there's no doubt about their application to Ukraine and to Russia in the current conflict. And they are completed with 2 additional protocols that were adopted in 1977. Now, the Geneva Conventions spell out the grave breaches, but we've also taken the same view of the Geneva Conventions as we do of the Hague Conventions, that other serious violations of the Geneva Conventions could amount to punishable war crimes under international law. The big distinction between the Hague Conventions and the Geneva Conventions in terms of what they address is that the Geneva Conventions address the victims of armed conflict. They don't address the conduct of the conflict itself. The 4 Geneva Conventions of 1949 deal with wounded soldiers who are unable to fight. They deal with prisoners of war, and they deal with civilians in an occupied territory. Whereas the Hague Conventions, although they also deal with those issues, they deal as well with the issues on the battlefield, the actual conduct of the hostilities. The protocols to the Geneva Conventions in some ways blend both the Geneva Conventions and the Hague Conventions. So all of these are sources of law, and they're, of course, relevant to the application of the provision in the Criminal Code of Ukraine, because we are going to turn to these documents, to these treaties, for evidence of what are the laws and customs of war, and therefore what are war crimes. Ukraine is not the first to have done this. The exercise was undertaken with regard to the Hague Conventions by the Nuremberg Tribunal, and much more recently, it was also undertaken by the International Criminal Tribunal for the former Yugoslavia in dealing with the wars that took place there between 1992 and 1999. So there's authority there for war crimes that clearly is going to be relevant in any prosecutions underway by the Ukrainian prosecutors. Just one final point about the role of the Hague Conventions and the Geneva Conventions, that as a source and as the distinctions between the two are also visible in Article 8 of the Rome Statute. So it's very possible to look at Article 8 of the Rome Statute, which is very long, which is the longest provision in the entire Rome Statute, and which is composed of, I can't remember the exact number now, but 40 or 50 distinct separate provisions dealing with war crimes. These reflect the law in the Hague Conventions and the Geneva Conventions and the protocols to the Geneva Conventions, as well as some perhaps more recent issues that have arisen in dealing with war crimes, like protection of the environment, prohibitions of child soldiers. Some more modern issues are also included, but certainly the structure of Article 8 of the Rome Statute can be broken down with reference to provisions, the grave breaches of the Geneva Conventions, and then the more general provisions on the laws and customs of war, and the provisions that come from the protocols. And all of this is broader, as I say, than what's in the Rome Statute. So the Rome Statute is a list that was agreed to in 1998, but it's not an exhaustive list of war crimes. The provision that was used by the Yugoslavia Tribunal, which now no longer exists in a technical sense, but which has a mechanism that perpetuates its work and where it can still, under very limited circumstances, conduct trials. It has a provision similar to the provision in the Criminal Code of Ukraine, and that provision in the Yugoslavia statute is broader than what we have in the Rome Statute. It has more crimes in it. It can cover more criminality, more criminal acts than what's in the Rome Statute. So an important reference in applying the relevant provision of the Criminal Code in Ukraine. The other sources that I've identified here that are also important is the Charter of the International Military Tribunal, that's the Nuremberg Tribunal, although it no longer applies strictly speaking. It not only was the governing law at the Nuremberg trial, but it influenced the subsequent trials before military tribunals of different countries, including the United States, and also, of course, Germany itself, where these laws were applied. And so we have direction there also from the Charter of the International Military Tribunal. One important difference is that the Charter of the International Military Tribunal not only deals with war crimes, but it also deals with this separate category of crimes against humanity, as does the Genocide Convention, which deals with what we might call one of the most extreme forms of crime against humanity. And then we get to the Rome Statute of 1998, and something that maybe isn't as well known. It's well enough known to specialists and people who work inside the court, but this is a document called the Elements of Crimes. So the Elements of Crimes is a subsidiary document to the Rome Statute. It reflects the provisions in Articles 6, 7, 8, and 8 bis of the Rome Statute, that is the definitions of the crimes, but it provides a little more detail. Sometimes when one reads the Elements of Crimes, they appear to add very little or nothing, in that they seem to just repeat what's in the Rome Statute. But there are places where we find additional elements that may be useful or significant. Just to give you one example, I don't think this is something that's going to arise in the current conflict in Ukraine, but it's an example where the elements provide something additional, is the crime of recruiting child soldiers. So the crime of recruiting child soldiers is in the Rome Statute. It refers to children who are under the age of 15 when they are enlisted or actively used or conscripted. And the question arises, and you'll all be familiar with this because we have other offenses, particularly sexual offenses, where the age of the victim is important. And we sometimes, and I don't know the law in Ukraine on this, but we have in many countries special rules that apply to the proof of the age and what's necessary to establish the age of the victims. And the Elements of Crimes suggest that the perpetrator cannot invoke as a defense the fact that they were mistaken, that they had a legitimate mistake about the age of the victim. This is not an admissible defense, and that's the case also often in countries with sexual offenses of that nature. So there are a few, but not very many. It just means that if you're dealing with a war crime, where you have a war crime that's being prosecuted and it's on a provision derived from the Rome Statute, it's necessary to check the Elements of Crimes as well. So this is basically an introduction into the sources of international criminal law. And of course, the standard, the main standard today, the authoritative standard, is the Rome Statute. But again, as I've said more than once, Article 8 of the Rome Statute is not a complete and an exhaustive list of war crimes. It's probably more correct to say that it is an exhaustive or a modern and widely accepted definition of crimes against humanity. But there are debates about this as well, as to whether the definition in the Rome Statute is itself narrower than the definition of crimes against humanity that was applied, for example, by the International Criminal Tribunal for the former Yugoslavia. I think that probably the only crime where we, and this is because the provisions are identical, is the definition of genocide in Article 6 of the Rome Statute, where the definition of genocide is the same in the Rome Statute as it is in the 1948 Convention. Two texts adopted 50 years apart and not a single change in them. And if you ever have genocide prosecutions in Ukraine, you can maybe look more closely at this. But our main concern is with war crimes prosecutions. Are there any questions about these issues before I move on to the next slide?
Dr. Shabas, I did see one comment here, question. I think you had mentioned it actually concerning the applicable law for the situation in Kursk right now. and somewhat similarly applicable law for Crimea or generally occupied territory in Ukraine?
Well, yes. I think that the position, and again, this is what the position would be taken by the International Criminal Court in investigations and prosecutions, is that they will consider that Crimea is an occupied territory, and that this would mean, for example, that the declarations by Ukraine that give jurisdiction to the court over its territory would include the territory of Crimea. And I don't know to what extent they're going to be prosecuting. I'm not sure if any of the 3 arrest warrants against the generals involve Crimea, but I'm not able to answer that question, but I think that would be the position. In Kursk, obviously the court doesn't have territorial jurisdiction over Russian territory because Russia has not ratified the Rome Statute or made a declaration recognizing the territorial jurisdiction of the court. But the Rome Statute would apply to nationals of Ukraine for any violations that they would commit in Kursk. So I think that to that extent in Kursk, because of the nature of the Rome Statute and the mix of personality jurisdiction and territorial jurisdiction that it creates, my initial reaction is that in Kursk, the Rome Statute applies to nationals of Ukraine, presumably Ukrainian soldiers, for war crimes that they might be charged with, but not to Russian soldiers in Ukraine because they're not otherwise covered. Of course, it's different when we're in the territory of Ukraine as such. I realize now, Christopher, as well, that when I was dealing with the previous slide, there was a question about the crimes against humanity provision and the application of that I don't know that I spoke to entirely. But of course, crimes against humanity are quite distinct from war crimes. In one respect, they apply in peacetime as well as in wartime, although I don't think this is really of concern to us, that distinction. It's an important feature of the definition of crimes against humanity, particularly when we have an authoritarian regime that is persecuting its own people on its own territory. And I think that's sort of farther from our area of interest. That being said, it's certainly going to be very possible to prosecute crimes against humanity in the occupied territories of Ukraine. I don't think that there's any difficulty with this. And the main differences between them, the provisions in the Rome Statute dealing with war crimes committed in an occupied territory are rather summary. Article 8 doesn't have a great deal to say about the law applicable in an occupied territory. It has some that's of relevance, including something that may be an issue, moving settlers, the transfers of populations could be dealt with under crimes against humanity as they can be dealt with under war crimes. But the interest of crimes against humanity is that they cover a broader range of acts as well, and in the definitions. And this may be relevant, and there may be prosecutions with regard to the crimes against humanity committed in occupied territories. The difference between a crime against humanity and a war crime is that you can prosecute a war crime even when it's rather isolated, even when it's an individual perpetrator, whereas when you want to get into the context of a crime against humanity, you have to demonstrate that it's part of a widespread or systematic attack and that it's pursuant to a policy. This is not necessary when we're dealing with a war crime. So, for example, sexual and gender-based violence perpetrated, for example, by a Russian soldier in occupied parts of Ukraine is a war crime and can be prosecuted as such, but it's not a crime against humanity. It can only be prosecuted as a crime against humanity if it can be demonstrated that this was not an isolated occurrence, but that it was part of a widespread or systematic attack. But there may be, I don't believe the prosecutor of the International Criminal Court has tried to pursue the idea of crimes against humanity in the occupied territories. Maybe, I'm sure the investigations are underway, but I don't think it's in the arrest warrants. One of our problems, of course, as you may know, with the arrest warrants that have been issued with regard to Ukraine is that the materials are quite secret. And so and this is an extraordinary situation. The International Criminal Court, which has operated for more than 20 years, it issued its first arrest warrants in 2005, so 19 years ago. And until recently, the applications for the arrest warrants and the arrest warrants themselves with the detailed description of the crimes were, as a general rule, quite public. But in the case of Ukraine, they have not been public. And so it's difficult for outsiders like myself to provide clear answers about everything. So the other main source of international criminal law that's important for us is the case law, the decisions of tribunals applying these provisions. And it's very normal, and no doubt it will be the case in Ukraine as well, for judges, domestic judges, to rely upon a range of legal authority from outside the system. So as a general rule, I'm sure that when Ukrainian judges are interpreting Ukrainian law, they are not really very interested in what the law is in a country in South America or in distant Asia or somewhere in Europe. But when it comes to international crimes that are derived from international law, the laws and customs of war, it is to be expected that judges will find the international case law. When I say international case law, I mean from both international tribunals, but also from domestic tribunals, to be of relevance. So let me just say a few words about the different sources here. These were the first international prosecutions, were the trials that were held in Nuremberg and Tokyo by the international military tribunals. We have a huge amount of documentation about these trials. We have a lot more about Nuremberg than we do about Tokyo. And certainly the materials from the Nuremberg trial are also available in multiple languages, which is not necessarily the case with the Tokyo Tribunal. So the Nuremberg Tribunal proceedings, 42 volumes of them, have been published in English, French, Russian, and I think in German as well. So those materials are quite readily accessible. I know that the English version is accessible in PDF online. I'm not sure about the other language versions, but they're certainly going to be available in law libraries, in university reference libraries, without any difficulty. Now, I think in terms of the practical utility of these, when we get to current day prosecutions, I think Nuremberg and Tokyo are likely to be rather limited in their scope. First of all, they didn't discuss in a huge amount of detail the content of the violations of the laws and customs of war. And they also didn't get into detail dealing with the perpetrators, because they were dealing with perpetrators at the highest levels. And I think we're likely to be seeing prosecutions. Certainly the people attending this webinar are likely to be seeing prosecutions of lower ranking military personnel, including even perhaps ordinary soldiers. And the military tribunals in Nuremberg and Tokyo dealt with the leaders. They dealt with the people at the very top, and these were people, none of whom had probably fired a gun or used a weapon at any point, you know, generals, admirals, and so on. So I don't want to suggest that they're entirely irrelevant, but I think that they are not likely to be the main source that you would need to turn to if you were defending somebody charged with violation of the Ukrainian law on war crimes. There were also in the courtroom in Nuremberg, maybe some of you have visited the courtroom in past years. The courtroom is still there in Nuremberg. It's now a memorial site, really, and although it may still be used for trials, it's mainly used for events commemorating the Nuremberg trial. We could do a wonderful webinar just about Nuremberg and Ukraine, because there was a lot of at Nuremberg in the trial that dealt with Ukraine. But it was it was an international military tribunal. As you may know, the lead Soviet prosecutor was a Ukrainian or of Ukrainian descent, as was the leading Soviet judge, Nikitchenko, Iona Nikitchenko. But when the trial was over, because the trial was in the American zone of occupied Germany, the Americans then took over the courtroom and had a series of trials for various thematic groups, doctors, judges and prosecutors, bankers, diplomats, generals, and so on. They held 12 of these trials. We call them the subsequent proceedings, and they were applying the law that had been used at Nuremberg. So they were, although they were national prosecutions by US military tribunals, they were actually applying international law. And we often turn to those materials. They're also available, but I think only in English, in PDF. And you can find them all on the website of for example, the Library of Congress in the United States. If you have any trouble finding them, send me an email and I'll send you the link, or I'll provide it to OSCE afterwards, and it can be circulated to the participants. But these materials are quite readily available, and they often deal with issues relating to prosecutions of war crimes that are quite important. And they also have in the proceedings, the subsequent proceedings, which are 15 volumes long. The 15th volume is a kind of summary of all of the legal findings. So it's like a textbook in international criminal law, again, potentially quite useful. But all of these earlier tribunals are overtaken really by the work of the ad hoc or temporary international criminal tribunals that were established for Yugoslavia, Rwanda, and Sierra Leone. And there's a huge body of judicial material from these tribunals that we continue to turn to for various specific issues that arise in prosecutions, including the very detailed types of problems that defense lawyers encounter, which are the definitions of the crimes, the availability of the defenses, of the excuses and justifications, the nature of evidence, rules about the types of evidence that are that are admissible, and the rules about participation and how people participate in these international crimes. And these are all relevant and potentially useful to a defense lawyer. I would think that a defense lawyer taking a case would really have a professional duty to make sure that those materials for the former Yugoslavia, Rwanda, and Sierra Leone are checked to see if there's relevant material that might be helpful to the defense. I wouldn't expect the prosecutors to bring to the attention of the judge or judges material that's helpful to the defense. This is really your responsibility, and so you know, pay attention to this source in particular. The material is all available online, although probably the best access to it is through some textbooks. So there are textbooks about these issues that refer to the authorities, and I think that it's probably going to be simpler, especially for people who are not really deeply familiar with all of this, to locate the relevant cases through a textbook or through an academic journal article, rather than simply going to the website and looking through the material. It's vast, it's enormous, so not an easy place for beginners, although if you work in it long enough, you'll become quite expert at canvassing the material. And finally, we have the International Criminal Court. The International Criminal Court has generated also a considerable amount of case law, but overall not nearly as much as the other tribunals. I should say as well that most of the case law of the International Criminal Court, as with the case law of the other tribunals, is concerned with domestic conflicts, with civil wars, with internal armed conflicts, rather than international armed conflicts, which is, of course, what we're dealing with here in Ukraine. And so there will be some limitations on it, but there will be areas where this is relevant. I'll give you an example of a type of case. I'm going to get to this maybe in more detail in a few minutes, but of the type of case that we do have, that's certainly going to be very relevant. At the International Criminal Tribunal for the former Yugoslavia, where Yugoslavia had broken up into different states, and to some extent, the conflicts there resembled international armed conflicts. And they also were characterized, the type of conflict that you have in the former, in Ukraine rather, also featured in some of the cases at the International Criminal Tribunal for the former Yugoslavia. Whereas in Rwanda and Sierra Leone, these were much more basic internal conflicts dealing with unsophisticated combatants in Rwanda and in Sierra Leone. But to go back to Yugoslavia, towards the end of the war in the former Yugoslavia, you had a part of Croatia that was controlled. It was essentially a Serb entity within Croatia that they had set up a kind of pseudo state. So it was in effect a territory that was largely populated by Serbs, but within the borders of Croatia, and it was beyond the control of the Croatian forces and the Croatian government. So to that extent, it was like an occupation in a international armed conflict, not unlike the situation that prevails in Ukraine. Towards the end of the war in 1995, as it became clear that they were heading towards a final peace settlement, there was an attempt by Croatia, a successful attempt, by the way, to remove that population and to retake the part of Croatia that was under this control of this Serb pseudo state. And so it was a more of a classic military engagement using artillery being fired at a long range. So this is the sort of thing that we see regularly in Ukraine at present. And it involved the issue of targeting and of indiscriminate attacks. and where the judges were divided as well as to how to determine that the use of artillery from a great distance, we're talking artillery being used to attack a town, an urban center, from a distance of 25 or 30 kilometers. And so the question was, were they targeting civilians, or were they, if not targeting civilians, indiscriminate in the use of weapons? These are questions that will arise, that have already arisen, I think, in some of the universal jurisdiction prosecutions dealing with the current conflict in Ukraine. And so the case law there at the Yugoslavia Tribunal is going to be relevant, although you may decide not to follow it. Courts may reject it. It was a controversial decision where you had 3 judges ruled at trial unanimously that the Croatian forces had committed war crimes, but this was reversed on appeal by a vote of 3-2 by the appeals chamber. So if you do the mathematics, you can see that you had 3 judges at trial and 2 judges on appeal who thought that Croatia had committed war crimes, but 3 judges on appeal who thought that it hadn't. And so the Croatians were acquitted of war crimes for the use of artillery in this manner. Probably not the most helpful judgment dealing with war crimes from the standpoint of the prosecutor, and an important judgment for the defense lawyers if they're dealing with a case of this nature. On the other hand, when we add up the judges, we see that it was 5-3 in favor of conviction. So I cannot begin to speculate on how that will be applied, but like most good, court cases, there are some good arguments on both sides, and it will be your job, I guess, to find the ones that are most helpful to the defense. And finally, and I'm going to stop and we'll take our next short break. Domestic courts and tribunals. There were domestic prosecutions for war crimes following the Second World War. Very few then subsequent to the Second World War until the modern period, the last 20 or 25 years. And now we have a lot of prosecutions for war crimes by domestic courts and tribunals who are referring to international law, and hence they're using provisions that will be relevant to Ukraine, even though they're sources from the courts of another country, not from international tribunals. We have the universal jurisdiction prosecutions, and there are several of them that are in the works in now dealing with Ukraine, in Germany, in France, possibly in Scandinavia. There are a number of countries where these are being undertaken, and those are going to be relevant. And you also have a certain number that you may want to turn to at some point, dealing with war crimes that come not from criminal tribunals, but from immigration tribunals, because the immigration courts in many countries will deny refugee status to somebody who is making a claim for refugee status if there are serious grounds to believe that they've committed a war crime. So sometimes that case law may also generate materials that are of use and of interest to defense counsel and to the courts and the prosecutors as well. Now, I suggest we take 10 minutes. It's now 11:55 in Ukraine, and we'll resume at 12:05 for our final session. Okay.
Very good. Thank you. Yes, please.
I think this slide on the international crimes I've actually dealt with, and I don't propose to linger on it unless there are questions. I didn't ask for questions about the last few slides, but if there are any, this is the time. Well, if not, let me talk about some of the war crimes and some of the difficulties with them. I think it's useful, although the Rome Statute doesn't do this in a strict sense, but that it's useful to distinguish between two types of war crimes. One category are the crimes that deal with the conduct of hostilities, what we sometimes call the battlefield offenses. This is about the law applicable between the combatants, really, and about the conduct of the fighting. And then the law, which I deal with on the next slide, which is the law dealing with those who are under the control of a party. These are mainly those in an occupied territory or prisoners. So let's go back. I'm sorry. Now, how do I go back? There. To the war crimes relating to the conduct of hostilities. And some of these are codified in the Rome Statute, and some of them are not. You will see in the Rome Statute that the provisions dealing with prohibited weapons, for example, are quite inadequate, and that you need to go beyond that to see how to prosecute prohibited weapons offenses. The provisions dealing with prohibited weapons are not going to be helpful, I think, generally in prosecutions in Ukraine, and are not going to be used because they deal mainly with archaic weapons. But the targeting offenses are going to be important. And it's clear to me from some of the materials, certainly the materials dealing with universal jurisdiction prosecutions, for example, in Germany, that there are very significant issues relating to targeting, and also from the limited information we have about the charges against the military leaders by the International Criminal Court prosecutor, that these two are going to involve issues of targeting. So we make this fundamental distinction when we're talking about targeting between a military objective and civilians or civilian objects. And the principle is simple, that you cannot target civilians and civilian objects. You can only target a military objective. But that's not the end, of course. It's not sufficient for the prosecutor to establish that it was a military objective or that it was not a military objective, because when military objectives are targeted, there may be incidental or collateral damage. This can happen both when the target is prohibited, that you kill civilians, but it can also happen when the target is perfectly lawful, but where the amount of damage is disproportionate. The collateral damage, the civilians who are killed as a result of the attack to the military objective. And there's a lot of material on this, but certainly these are cases that have proven to be difficult to prosecute, and where there will be useful arguments to be raised by defense counsel, as was the case that I referred to before at the International Criminal Tribunal for the former Yugoslavia. And then the idea that an attack is indiscriminate. Well, it's actually hard to prove that an attack is indiscriminate. There are suggestions, and I think this is in one of the universal jurisdiction cases filed in Germany by the Clooney Foundation, is that they were using weapons that were inherently indiscriminate. And I think this is a difficult thing to establish. We're going to have some prosecutions on that, probably, as we will, incidentally, in a conflict that's of course, not related at all to the Ukraine conflict, but where similar types of issues are going to arise, which is all of the debates about war crimes committed in Gaza at present. And we're expecting the issuance of arrest warrants on that, although I don't know that they're going to deal with the conduct of hostilities. They seem to be directed to the issue of starvation. So I don't know how relevant that will be, but there certainly are going to be prosecutions about the attacks. So the issues arise about the choice of the targets, identifying a military objective, distinguishing it from a civilian object, but then trying to prosecute a case where issues like proportionality and indiscriminate attacks arise. And I think, again, that there will be much material for defense lawyers if they're involved in having to defend these cases. You may find it necessary and useful then to get expert advice from people in the military, from military experts. I recognize that in the context of Ukraine, it may not be a simple thing to find a military expert who's prepared to act in defense, except that these are rules, as you know, that work in both directions. And so if Ukrainian prosecutors adopt an approach to indiscriminate attacks that's very, very strict and that favors prosecution, that this is going to possibly backfire and be used in prosecutions against Ukrainians as well. So this is where I guess a close look at the practice has to be involved. And you may find that there are military personnel in Ukraine who will be very, very nervous about interpretations of notions of indiscriminate attacks that will reflect badly on them as well. So I think this is something to be borne in mind in dealing with targeting offenses. My impression in looking at the former Yugoslavia, in looking at Gaza, but also in looking at Ukraine, is that these have historically been very hard cases to prosecute. And that means that they are historically cases that are, I don't want to say easy to defend, because nothing's easy, but where the defense lawyers have a good chance. So bear that in mind if you're involved in cases dealing with targeting. I don't know how many of them are likely to arise, but if you are. And then finally, we have these issues about the destruction of property that's not justified by military necessity. Again, that's relating to the military objectives and the collateral damage. But obviously, any attack on buildings, structures, property, and so on that does not have any obvious military use could be a war crime. But once again, bear in mind that these are all, given the nature of the conflict, these are all about establishing legal rules and principles applicable to the conflict that have the potential to be very harmful to Ukrainian forces as well as the Russian forces, and that this will be, I think, something to the extent that you're involved in defending people charged with the crimes, it will be perhaps a dimension that it's important to bring out. I've already spoken about prohibited weapons, and this is potentially, of course, broader than what's in the Rome Statute. The Rome Statute is quite inadequate. We don't have the classic examples, I think, in the Ukrainian conflict of hollow tip bullets and poison and so on, but there may be some prohibited weapons charges that arise. Surrender has been an issue of some significance, and in another context, I did some sessions with prosecutors and military lawyers about issues surrounding surrender. There may be prosecutions that arise concerning attempts to surrender, where those attempting to surrender were killed as they attempted to surrender, or where those who were receiving the surrender were themselves tricked and were themselves killed or wounded when an attempt or an attempted surrender was suggested that was really a trap for the opposing forces. And I was asked to provide more detail about the law that applies. Again, in looking at the applicable law, I found it to be extremely difficult to get good guidance on this, and it became clear to me as well that for the soldier on the battlefield, the context of surrender is one of the scariest and most dangerous situations for a combatant. I say that as somebody who never did military service and was never in a war, but in looking at all of the authorities, it seemed to me to be an extremely problematic situation. The basic rule, of course, is that a prisoner who's attempting to surrender has to be allowed to surrender, first of all, that surrender cannot be refused. It would be a war crime to refuse surrender. But at the same time, the act of surrendering raises all kinds of difficult issues. And so if you have prosecutions involving that, I don't even know where to tell you to turn. But to say that it's an area that's extremely difficult. It's related to the next point here on my slide about what we call acts of perfidy or ruses or tricks of war. So war, conflict, is all about trying to trick the enemy, trying to mislead the enemy, to suggest to the enemy that what they see is not actually what is happening, and to use that to the advantage of the other side. But there's a point where tricks are not allowed. And I think basically we use this term perfidy in the English language. Perfidy is where you exploit the fact that you expect the other side to obey the laws of war in order to attack them. And I think a classic example there is using a white flag, or, for example, the emblem of the Red Cross, to suggest a surrender, but where it isn't actually, it's a way of tricking the enemy into not being vigilant and therefore being vulnerable to an attack. And that's obviously prohibited. The distinction between this is not always entirely clear. And I think, again, if there are cases relating to the conduct of hostilities, these are going to arise. Once again, my advice to defense lawyers, if you're involved in cases dealing with the conduct of hostilities, is to get some experienced soldiers to give you a little advice on what they think is and is not acceptable. Now, the other part, which is something that we're going to see much more of, and is much more a feature of the conflict, is war crimes relating to persons who are under the control of a party. So here we have the cases of sexual and gender-based violence, prisoner offenses relating to treatment of prisoners of war and prisoner of war status, and the acts of abuse generally committed against prisoners and civilians in an occupied territory. And finally, the case that has become the basis of the charges against Putin and Lvova Belova is the transfer of populations. Let's go back to the first one, sexual and gender-based violence. I gave you two scenarios of problems, and one of them dealt with sexual and gender-based violence, where we're dealing with a soldier who developed a relationship with a woman in an occupied territory that was ostensibly, at least according to the soldier, entirely consensual, and where the victim became pregnant, but where after the soldier was left the territory, was arrested, charged with with sexual and gender-based violence, and where the victim claimed that there was no consent. And I said to you, asked the question, you know, if this were to go to trial, and again, your defense lawyers, probably many of you have had experience dealing with cases of sexual and gender-based violence where there is little or no evidence to corroborate one version or the other. We call these sometimes he said, she said cases, where it's really the word of one person against the other. And that was the scenario I was trying to suggest, and I wondered whether there was another argument that the accused might be able to invoke, that the defense might be able to invoke. Do any of you have any thoughts on this? No volunteers?
I did enter the question into the comment section for those who might have not seen it, but I think everyone has had a chance to have taken a look at it before the webinar, but the hypothetical is now in the comments as well. You're welcome to put forward any thoughts, reflections, comments, or questions.
Well, we have no volunteers. I'll have to tell you the answer then. I'll tell you what I was trying to get at. One of the requirements for a war crime is that it has to have a connection to the war. And when we're dealing with the first category of war crimes, which are the offenses on the battlefield, this is never going to be an issue, because everything is, by its very nature, related to the war. We call this technically, the term we use is nexus, which is a Latin word. We say it has to have a nexus with the conflict. And so when we're dealing with the conduct of hostilities and offenses on the battlefield, the nexus on the conflict is, as a general rule, going to be entirely obvious and straightforward. But it's not always the case when we're dealing with offenses relating to persons under the control of a party, because there may be crimes that take place in an occupied territory that are just ordinary crimes. Criminals who commit crimes in peacetime don't stop committing crimes because it's a war. And so this is about really drawing a line between ordinary crimes and crimes that are war crimes, and therefore subject to the jurisdiction of the International Criminal Court, universal jurisdiction, and so on. And sexual and gender-based violence is a good example, because sexual and gender-based violence is a crime anyway. It's a crime in the criminal code of Ukraine. We don't need the international law in order to prosecute sexual and gender-based violence committed in Ukraine. We do need to have that connection, though, if we're going to prosecute it at the International Criminal Court or under universal jurisdiction. So this issue about distinguishing between ordinary crimes and international war crimes becomes a real live issue. We have it arising in other contexts as well. For example, in occupied parts of Ukraine, if the Russian forces were to destroy a cultural monument, that would be a war crime. Not because the monument is inherently protected, but because the Russians are not allowed to destroy cultural property that belongs to the Ukrainians. On the other hand, if Ukrainians decide to destroy a cultural monument inside Ukraine, this would not be a war crime. It would not be a war crime. It has no connection with the war. Ukraine is entitled to destroy or to build monuments as it sees fit. It can do it in peacetime, and it can do it in wartime. So this is the issue that arises, and I was just raising the issue that a soldier who had a relationship, consensual relationship with someone in an occupied territory who would be a protected person is not necessarily committing a war crime. I think that's the point. They're not necessarily committing a war crime. We could move the scenario from occupied Ukraine to Kursk, to occupied Russia, where it's not beyond the imagination that a Ukrainian soldier could develop a personal relationship with someone who's a resident of that territory. And would that then be a war crime? Is it automatically a war crime to have sexual relations with someone in an occupied territory, or does it require something further? The prosecutor, by the way, is almost always going to argue that it's automatically a war crime, and that in fact there is no such thing as a non-consensual relationship between a soldier of an occupying power and a civilian in the occupied territory. But it's for the defense counsel to raise the argument and say that that's not always the case, that in fact the court would be required to look more closely to see whether there was evidence of consent, and that consent would be a defense. Whereas the prosecutor, and they've done this in war crimes trials in former Yugoslavia and elsewhere, prosecutors have argued that there's no defense of consent to sexual relations between a combatant and a civilian. Any questions about these categories of crimes? Crimes, persons under control of a party, and I'm very anxious to see how the transfer of populations offenses are going to turn out with regard to the children, particularly in the occupied territories. As I say, it's been a source of great frustration to legal observers like myself, because we lack the materials that we need to study and to understand what those crimes are really about. We need to see the submissions by the prosecutor, and we need to see what the judges have decided and what the arrest warrant actually says. And those materials have been kept secret. It's difficult to understand why they're secret, because they've been made public in other situations before the International Criminal Court. They've never been considered to be secret, and where it was necessary to protect victims, this can be achieved by making parts of the materials inaccessible in order. This is a normal procedure at the International Criminal Court. Let me turn then to another issue that will inevitably arise in prosecutions, that arises in prosecutions for war crimes, and where there is a degree of tension between the law applicable internationally and the law applicable at the national level. We talked earlier about the implementation of the Rome Statute in the laws of Ukraine, and how there's no requirement of the Rome Statute that there be legislation, but it's likely that there will be legislation, and that it will introduce various forms of, that it will introduce crimes, if necessary, particularly the definition of crimes against humanity, I would expect. Maybe some changes to the definition of war crimes, although I think this is probably not necessary. But what about the modes of liability? What about the forms of participation in the crimes? I would say that most countries, when they implement the Rome Statute, implement the crimes themselves, take the definitions in Articles 6, 7, 8, and 8 bis of the Rome Statute, that is the definitions of war crimes, crimes against humanity, genocide, and sometimes the crime of aggression, and insert it into their criminal code in the special part of the criminal code, as if that's all that's necessary. But they make no change to the general part And my slides, this one and the next one, deal with these issues that arise when the general part of criminal law is applied to these international crimes and how that may work in prosecutions before national courts. And that's because the Rome Statute has its own definitions of forms of liability, of modes of liability. It also has its own definitions of available excuses, justifications, defenses. And the question is, can we apply these at the domestic level? And you may find that as defense lawyers, that it's more helpful for you to rely upon the international legal provisions and to argue that the international legal provisions, which are sometimes narrower than what we have at the international, at the national level, should be applied by the courts. This is consistent with the notions of complementarity. So I would urge you to consider this. You will find that in the Rome Statute, there's a rather detailed description of the notions of, first of all, of perpetration. Who is a perpetrator? How do you perpetrate a crime? And how do you become an accomplice in the crime? And there's a detailed codification of these rules that has been controversial before the court as to what is involved. And it's mainly a debate between German lawyers and British lawyers, I think, and American lawyers as to the nature of perpetration, whether we consider, for example, the person who stands behind the crime and gives the orders, or who is the commander, but who doesn't actually physically commit the crime, whether we consider them to be a perpetrator or an accomplice. And this is also related to the idea whether being an accomplice is necessarily a secondary form of criminal responsibility, or whether it's just as bad to be an accomplice. So these modes of liability have been subject of much debate, and they're not entirely unresolved. I think one of the issues that remains unresolved at the International Criminal Court is whether an accomplice has to make a significant or a substantial contribution to the crime, or whether an accomplice can make even a minor or secondary contribution to a crime. And I would expect this to arise in war crimes prosecutions. I don't know what the rule is in Ukraine, in Ukrainian criminal law. You will all know this, of course, as to how much participation is required for somebody to be deemed an accomplice. But there's certainly authority at the international level that to be an accomplice in a war crime, you have to have made a significant or a substantial contribution rather than a secondary or a minor contribution. The other form of liability, which is quite unique to the international level and which is not reflected in many domestic criminal justice systems, is what we call command or superior responsibility. And if you want to see where this is spelled out, you need to refer to Article 28 of the Rome Statute. Article 25 is the provision that describes the forms of perpetration, complicity. It also deals with attempts and so on. But Article 28 describes something quite different, which is a form of, it's called a form of participation in the crime, but in many ways it takes the form of the actual commission of the crime itself. Let me explain. This all goes back to a famous case at the time of the Second World War. It was a prosecution by an American military tribunal of a Japanese commander who had been in charge of troops in the city of Manila, but who had lost contact with them, who was not able to control the troops. Certainly this was what he argued in defense. And the troops in the capital city of the Philippines created terrible destruction in the final days of the war. So the general was prosecuted. And in defense, he said, well, I didn't order them to do this, and I was not in control of them. I couldn't stop them from doing it. And the court said it didn't matter, that because he was the commander, he was responsible for what they did. So this is a form of liability that we would not normally have in domestic law. First of all, because the notion of commander only really applies in a military or a police context, but superior, even a civilian superior, some of you perhaps are criminal defense lawyers, so perhaps you're not in that situation, but many of us have worked in an environment in government, for example, or in the private sector, where we have a position, a superior position, whether we have people under who are responsible to us, who report to us. Are we criminally responsible for what they do? I think the general rule in domestic law is no, that we're not criminally responsible for what they do. We're criminally responsible if it can be shown that we told them to do it or that we ordered them to do it. But if we don't, the closest I think that we come to this is the responsibility that we attribute in private law and civil law to parents and to school teachers for the acts of children for whom they're responsible. But this is generally a form of liability at the civil level rather than at the criminal level. Again, I'm obviously not fully informed about the laws of Ukraine, but I would be astonished if a parent could be prosecuted for a crime committed by a child where it could be shown that the parent did not know the child was committing the crime and wasn't in some way ordering them to commit it. Children often do things that their parents don't want them to do, and we may make them responsible to pay for the damage, but we don't send them to jail for things that they didn't want their children to do and did their best to prevent them from doing. But we behave differently when we're talking about war crimes. And it's related to the idea that the commander of troops who are armed and who are involved in armed conflict has some special responsibility. So this notion, as I say, was recognized initially in a few trials following the Second World War. And then it was codified when the Yugoslavia Tribunal was set up, and then subsequently in the International Criminal Court. Prosecutors love it. Prosecutors love this notion because it makes it possible to convict more senior officials, particularly military officials, but also civilian officials, for acts where we have no evidence at all that they ordered the crime to be committed. But simply because of their position, it's really more like a negligence type of crime. Although judges constantly say this is not a negligence crime, when you see the formulation, you'll realize that it is in fact formulated as a form of negligence crime, because we say that the commander knew or had reason to know. The commander knew or should have known that the troops were going to commit the crimes, that the people under their command were going to commit the crimes. And as I say, we don't generally have this in national systems, and in some countries, like Canada and Germany, that attempted to very dutifully implement the provisions of the Rome Statute, they didn't do this. They didn't add this, so that if there's a case involving command responsibility in Germany or in Canada, they won't be able to prosecute them. That they will fail the complementarity test because they can't do it. And I think that in both cases, they took this approach because they had constitutional problems with doing it, because the idea that you could hold somebody criminally responsible for a very serious crime, a war crime, without evidence of any criminal intent, but other than that they were negligent in the supervision of their subordinates, is something that is offensive at the constitutional level in those countries. That would not be acceptable. So this is something that Ukraine will possibly implement into the criminal code if it does so, or that the prosecutor might even try to apply in the absence of a provision in war crimes prosecutions, is to really, in effect, reduce the level of responsibility for commanders so that you don't have to prove criminal intent of the commander other than negligence in the command. These should be, on the one hand, they're beloved of prosecutors. They're a big problem for defense lawyers. But that being said, defense lawyers have had a good record in defeating such charges. At the International Criminal Court, they had one trial that was built upon the theory of command responsibility, and after a lengthy trial, 3 of the 5 appeals judges ordered an acquittal. So it looks simple for the prosecutor. It looks like a gift for the prosecutor, but in practice, they've proven to be hard cases to prosecute, and cases where there are good arguments and where the defense has a good chance. So I would just make that observation should you encounter this in prosecutions dealing with war crimes. So I think this is my final slide. We'll conclude with this, dealing with the defenses, the justifications, the excuses. Depending on the legal system, we call them defenses in some legal systems. The Rome Statute produces a codification of these defenses, and they are issues that arise, and this is really the bread and butter of the defense lawyer. As you have a charge, and the question is, what are the defenses that you can raise? Again, in Ukrainian law, you may have the codified defenses. I'm speaking here about the defenses that are codified in the Rome Statute. And there is a fairly good list of them, although it's not an exhaustive list. The Rome Statute allows for certain defenses that are not actually codified in the Rome Statute. They may be available as a defense. Let me give you an example. It's not on the slide, but let me give you an example of something that may be a defense to a charge of war crimes that is not explicitly listed in the Rome Statute, but where most commentators agree that there's the possibility of invoking it, and where at least one country, the United Kingdom, when it ratified the Rome Statute, made it clear in a statement that it considered this to be a defense. And this is what we call reprisal. So a reprisal is a defense. You invoke the reprisal to a charge of a crime where the actual criminal act, the proof is, the evidence is that you committed the actual criminal act. You committed what is normally a war crime, but your defense is that you were doing it as a reprisal. And a reprisal means you were doing it because the other side had committed a war crime. And this is an ancient notion in the law of war crimes. The idea of war crimes is, historically, we can go back hundreds and hundreds of years. We can go back to antiquity to find examples of what the Hague Conventions called the customs of war. And of course, you have that terminology in the current provision in the Ukrainian criminal code. The idea that you could do something that was ostensibly the physical act of the war crime, but for which you were doing it because the other side had committed a war crime. And in ancient times, this was really the only answer to a war crime, if one side committed a war crime, then the other side, it was no use for the other side to say, we'll see you in court when the war is over. There was no court. They had to make the side that was violating the laws of war comply with the laws of war. And the way you did it was by saying, if you commit a war crime, then we're going to do it to you. Of course, the rules were established a long time ago that the response had to be proportionate to the violation, and that it had to be done with the purpose of stopping the violation, so that when the violation stopped, the reprisal stopped. So today, we have provisions in the laws, in the law dealing with prisoners of war, that reprisals against prisoners of war are prohibited. So if you have a case of someone, you're defending someone who committed a war crime against a prisoner of war, and they say, this is because you're committing war crimes against our prisoners, forget it. You're going to lose that argument because the law is clear. You cannot invoke a defense of reprisal for a crime committed against a prisoner of war. It's the same with civilians. In the protocols to the Geneva Conventions of 1977, it's clear that you cannot commit reprisals against civilians. But against combatants, it seems to me that the law still authorizes that. It's still possible that if there are war crimes committed in the conduct of hostilities against combatants, that it's possible to succeed with the defense of a war crime by saying you were doing it to stop the other side from committing war crimes. Whether this will arise in the conflict is a question I can't answer, but I'm really just providing this as an example of the fact that there are some defenses to war crimes that are not actually set out in the Rome Statute. But let's turn now to the ones that are set out in the Rome Statute. Mistake. So mistake of fact will always be a defense, as it is a defense in ordinary criminal law. Subject occasionally to special rules that we have, for example, to mistake about the age of the victim. And I referred to this in my earlier comments today about how this could arise, for example, in the case of child soldiers. That problem I don't think we're going to encounter in Ukraine. But mistake of fact, for example, about targeting. So I referred earlier to the issue of targeting and what's a lawful target and what's an unlawful target. But obviously, mistakes happen in targeting, and a mistake can be a defense. Of course, it has to be a reasonable mistake. It has to, you have to, it's too easy, obviously, in all circumstances, for someone just to say, oh, well, I made a mistake. So that there has to be this reality about the mistake of fact. But mistake of fact in principle is always going to work as a defense, subject again to these exceptional cases where we say that the mistake of fact, that if you're negligent about the fact, for example, the age of the victim, but these are rare cases, unlikely to arise. What about mistake of law? Well, the rule at the Rome Statute, as is the rule in all legal systems, is that mistake of law is not a defense. I think that's clear. But we sometimes have cases where the mistake of law blends in with the mistake of fact issue. And so there are some sort of hybrid cases where there's a combination of a mistake of law and a mistake of fact. For example, a mistake of law, not about what is or is not a war crime, but about the legal status of someone, as to whether the legal status as to whether, for example, property is civilian property or not, or whether it's protected property. You're not allowed to destroy a historic monument, but there would be some issues about the ownership of the monument and so on that might complicate this. But these are rare questions that arise, but you should be aware that this is the status of mistake of fact. Superior orders is more complicated, and as a general rule, our soldiers at a certain level, but this goes up through the hierarchy, because all soldiers except for the field marshal or the general who's in charge of the army, everyone is following orders through the hierarchy, and superior orders have always been raised in prosecutions dealing with war crimes, at least historically. And I gave you a problem, sort of another scenario, where I asked you whether there was a defense of superior orders available. Does anybody have any reaction to that scenario? Well, if no one wants to speak to it, I gave you these scenarios because I just wanted you to reflect on some of the types of problems. You will, no doubt, if there's a prosecution where there's an issue of superior orders that arises, where the accused person was acting under superior orders, where that's a fact that's not in dispute, the prosecutor is likely to say this can never be a defense. And we have provisions in the statute in the statute of the Yugoslavia Tribunal, in the statute of the Rwanda Tribunal, and in the charter of the Nuremberg Tribunal that all say quite clearly and blatantly, superior orders is not a defense. But the Rome statute is a little more nuanced about this. And I think it will be important for defense lawyers to know that if the issue of superior orders arises, you want to turn to Article 33 of the Rome statute, because it approaches this in a more, I think, sophisticated way. And it says that superior orders can be a defense to a soldier charged with a war crime, to the extent that the order to commit the crime was not, and the term that's used in the Rome statute is manifestly unlawful. So the issue there is whether the order is manifestly unlawful. And this is an issue that I think will require defense lawyers to probe the nature of the order, rather than simply accepting the claim of the prosecutor that superior orders are not a defense. I gave the example a few minutes ago of an order to commit a reprisal. Suppose the person you're asked to defend is a soldier on the battlefield who is ordered to use a prohibited weapon, or to do something that's some other thing that is probably a war crime. And the order is to commit the war crime, and the soldier turns to the commander and says, but I think that's a war crime. I'm not supposed to do it. And if the commander says it's a reprisal, we're doing it because the other side did it, is that then, does it then become not manifestly unlawful? It was manifestly unlawful to the soldier who objected, but then the commander said, but it's a reprisal. Now, if we had, I'm here alone as the purported expert on international law, if we had a panel here of half a dozen university professors who are specialists in the law of armed conflict, we would argue about this. We would have a debate. And I think some would say, no, you cannot have a reprisal. They're against international law. And others would say, well, actually, you can under certain limited circumstances. The fact that we have that debate maybe proves that the order is not manifestly unlawful. What I'm saying is that there's some room there for the soldier charged with a war crime where there's a defense of superior orders to argue that in some way it was not manifestly unlawful. The laws of armed conflict are quite sophisticated. The case law is complicated. It's complicated for the defense lawyers. It's complicated for the academics who study this. How can it not be complicated for the soldier? It's not like domestic law, where we're dealing with rape and murder and theft, where everybody knows the law and everybody understands the law. So I raise this point as saying this is something that may arise and may be relevant. Let me conclude, because I think the time is short now, and I'm going to touch on the final three defenses that are issued. Self-defense is obviously, I think the rules on self-defense are essentially the same as you know them in domestic law. There's an attempt, again, in the Rome Statute to codify this. You may want to refer to this. I would say that you should bear in mind, in looking at the Rome Statute, that this is the description of the defenses is never going to be identical to what you have in domestic law, because it is very deliberately an attempt to devise a compromise package of criminal law that works for all countries or most countries. So there's no attempt to have one legal system, the French legal system, the American legal system, the British legal system, the Russian legal system. There's no attempt to try and replicate that, but rather to find rules that are going to work and be acceptable everywhere. And so these provisions don't entirely replicate what you have in domestic law, and they may differ slightly from what you have in domestic law. And there will be times when that difference is helpful to the prosecutor, and there will be times when that difference is helpful to the defense. The second last category, duress. This is the defense where somebody says, I was forced to commit the crime. We had a famous example at the Yugoslavia tribunal of a soldier who participated in the terrible massacre at Srebrenica, which we now call the genocide in Srebrenica, where 7,000 to 8,000 Bosnians were murdered by Bosnian Serb troops. And he said, they told me that I had to go and kill the soldiers. This is what a Serb soldier defended. The defense was, they told me I had to do it, and I was going to be punished if I didn't. And so we're familiar with this defense, how it works in domestic cases. It may arise occasionally. My impression is that it's almost never successful as a defense, although it doesn't mean it's not worth trying, because it rarely has an air of reality to it. We had cases during the Second World War where SS officers were punished for refusing to participate in various massacres, like the notorious massacre in Kiev, in Babyn Yar, and they were demoted, they were sanctioned, but their lives were not threatened. In reality, it was impossible for them to prove this. And finally, and I think this is something where you may have many opportunities for defense, is mental incapacity. And that issue may arise, again, like all of these defenses, they arise not only as pure defenses, but the evidence of them may also be relevant in determining the sentence. Even if your client is going to be convicted, the fact that one of these factors is present may help to reduce the sentence. And of course, much of what we do as defense lawyers is not so much about guilt and innocence as making sure that the penalty that's imposed on the person is a fair and reasonable penalty, and not necessarily the penalty that the prosecutor is seeking. I think with that, Christopher, we are just about at the end.
Indeed, indeed. I think we are. Perfect timing. We managed to fit so much robust information on different topics into a very short period of time. I'd like to thank all the participants for their attention, their questions. I noted a lot of interest concerning ratification, and I'm sure we'll discuss that more in the weeks and months ahead. And thanks to the interpretation, the IT support as well for your work and capturing all these complex ideas. Special thanks again to interpretation for working to provide us with good communication across various channels. Of course, many thanks to the Coordination Center for co-organizing this with OSC ODIHR. And most importantly, Dr. Shabas, thank you for a very interesting, fascinating, and engaging webinar. And if there are any participants who have any questions for you or any comments, I am happy to send them your way from them on your behalf. One last reminder today that 1 week from today we'll have the second session in the series of these webinars titled Practical, Procedural, and Fair Trial Concerns in the Domestic Adjudication of War Crimes Cases. One more time, that's 1 week from today on September 11th. With that said, I wish a most sincere, peaceful day, a peaceful week ahead to all our Ukrainian friends and partners. And we hope to see you next week in our next session. And I wish you all a good day. Thank you very much.